Hello, everyone, and welcome to our third Tuesday webinar, Getting into the Weeds on FMLA, Part 3, Managing the Leave Process, Reinstatement, and Interplay with Other Laws. My name is Michael Johnson. I'm the Director of Content at myHRcounsel.com. Thank you again for joining us, and apologies for any audio issues that you may have experienced with a recent broadcast of this information. Today we're going to talk about managing FMLA leave. We're going to talk about reinstatement of an employee who's been on FMLA leave, and we're going to talk about the interplay of FMLA with other laws. First, of course, we need to go through some housekeeping items. As you're listening here, this presentation is being recorded. After the presentation, we're going to send you out an email as an attendee with a link to the recording, the HRCI credit code, any Q&A that we receive regarding the presentation, and also a brief survey. We ask that you please complete the survey because it lets us know how we're doing and also lets us know about what topics you would like us to present on at future webinars. This is how we came up with the topic idea for today. In fact, FMLA is a very popular area where people have many questions. So you have asked and we are delivering. You'll also receive in the email our FMLA decision tree document. This is basically meant to walk you through each step of determining whether an employee qualifies for FMLA leave. You should receive these items within the next few business days from us. And we do have a lot of material to cover today, and I'll be looking at the questions as they come in and answering any questions as time permits. Additionally, just so you know, this is basically for general information and educational purposes only. We always have to provide our legal disclaimer. We can't provide specific legal advice in this format. If you're one of our clients, we can follow up in depth after you go through the presentation if you have specific questions on specific employees. And if you're not one of our clients, you do need some assistance, be sure to sign up for myHRcounsel. So let's kick it off with our starting point today. And you've got an employee, they're on FMLA leave as was discussed in the previous Tuesday webinars. Now what? When the employee is on leave, this can arguably be the most difficult part of the entire FMLA process. There's something to think about really starting at the very base level. The employer must accurately calculate and track available leave hours for an employee. This is the key to successful management of FMLA leave. Employers also have to manage what we like to call the dreaded intermittent leave, or reduced hour leave. And employers have to determine what pay and benefits employees on leave will receive. And you've got to look at factors that include not only the rules under the FMLA, but a range of other laws as well. And we will discuss that further as we go along here. In addition to you being responsible for managing and tracking leave, the employer must also take into account other legal landmines that can be encountered while an employee is on leave. Some of those include discipline of an employee. What if they have to be terminated? What if the company goes through a job elimination for that position? Or what if there are a series of layoffs or a reduction in force that occurs? We're going to discuss those topics as well as we go along. But let's get back to what we just had talked about, and that's counting and tracking FMLA hours. There are a number of questions that employers normally face when they're trying to determine the amount of leave, FMLA leave an employee is using. And those include, what is the relevant time period to consider for the FMLA leave? What time increments should be used when I'm looking at an employee who's taking FMLA leave? How are holidays going to impact my analysis of time used for FMLA? What about an employee who works overtime? And are the counting rules the same for all employees? So let's start off by looking at the 12-month period that an employer uses to calculate an employee's FMLA leave usage. This was covered in the first episode of our webcast series, but it bears repeating. So we're saying it again here. Choose your 12-month period ahead of time and apply it equally. That's an important practice for employers to have with their FMLA policy. Get your 12-month period established before people start using FMLA leave, and then make sure employees are treated equally. So there are several different ways that an employer can calculate the 12-month period. We're going to go through the 4 options that exist. So one way is to use a 12-month calendar year, January to December, straightforward. Another method that employers use is any fixed 12-month period. For example, some employers might use their fiscal year, which is different than the calendar year. The other 2 methods you could potentially use are a rolling 12-month period measured forward or a rolling 12-month period measured backwards. So employers are free to choose any one of these alternatives provided they apply the selected alternative to all employees consistently and uniformly. If you want to switch methods, say you want to switch between the calendar year and move to like a rolling 12-month period measured forward, you must provide 60 days notice of the pending change to all employees. And then during that 60-day notice period, an employee can rely on whichever method affords them the greatest benefit. So again, if you're moving from a 12-month calendar year period of calculation to a rolling 12-month period measured forward, whichever one of those would give the employee more leave is the one that you would be required to allow them to use. If an employer fails to select a particular method before an employee takes leave, that means the employee will be granted the option that provides the most leave possible. So if you don't have a policy in place, in other words, an employee could choose between any of the 4 methods shown to figure out which date would be better for them. Now you've got notation here about preventing stacking and not preventing stacking. So let's talk about that a little bit. What is FMLA stacking? That means an employee is taking FMLA leave for a subsequent FMLA leave year right after they have taken FMLA leave during the previous leave year. So for example, say you have an employee that takes 12 weeks of leave ending, say, towards the end of December. If you've got a 12-month calendar year for your 12-month period that you use for FMLA accounting, an eligible employee could then turn around in January and begin a new 12-month or new 12-week chunk of FMLA leave starting January 1st. So you could basically have an employee taking 12 weeks in the previous calendar year up to December 31st, and then taking another 12 weeks right away starting on January 1st of the next year. That is if you're using the 12-month calendar year. So as shown on the slide, the first 2 options are easier to calculate in terms of your 12-month period, somebody using leave to track FMLA leave use, but they don't prevent the stacking that we just discussed. The second 2 ideas, they do prevent the stacking, the rolling 12-month period forward and the rolling 12-month period measured backward, but they are a little more difficult from an administrative standpoint to manage. So that's just something to keep in mind as an employer. Now let's talk about another aspect of FMLA leave that comes into play not super often, but it's a big part of the law, and that's covered service member leave. So we had just talked about the 4 different methods that an employer can choose for determining the 12 months when an employee can use their FMLA leave. It's a little bit different to calculate the 12-month period when you're looking at covered service member leave. So remember that eligible employees are entitled to up to 26 weeks of covered service member leave in a single 12-month period to care for a covered service member. The 12-month period always begins on the first day of the leave period and ends 12 months later. So you cannot use rolling 12-month period with this type of covered service member leave. That means that employees may be able to take multiple leave periods. The regulations, just as some background, provide that covered service member leave is applied on a per covered service member as well as per injury basis. So somebody could conceivably have more than one person that's a covered service member where they could be eligible for this leave. They could also have a single person that they're caring for under covered service member leave that could have more than one injury. So an employee might be able to take more than one and potentially overlapping 26-week periods of covered service member leave. If you're an employer and you've got an employee using this type of leave, you've got to very carefully assess and track when each individual leave period begins and the amount of leave taken in each separate 12-month period. Again, this is not something that comes up very often, but it's something to be aware of if you have any employees who are going to care for a covered service member. Now, counting the leave time. There's some different things to keep in mind. FMLA leave entitlements are defined as a given number of weeks. Part-time employees' leave time should be counted on a pro rata basis. Employers can convert these fractions to an hourly equivalent, and intermittent leave may be taken in increments no greater than the shortest period of time that the employer uses to account for other types of leaves. Can't be greater than 1 hour. So let's get into a little bit of depth on these bullet points. The regulations emphasize that an employee's actual work week forms the basis of the leave entitlement. So where you can, an employer has to calculate the amount of leave time used in full week or percentage of week increments. For example, if an employee normally works 5 days a week, takes 1 full day of leave, the employee has used 1/5 of a week of FMLA leave. In another example, if the employee normally works 6 days a week, the employee has used only 1/6 of a week, and so on if they were to take 1 day off. If an employee takes an intermittent or reduced schedule leave, the leave entitlement is calculated by comparing the new schedule with the employee's normal part-time schedule. So for example, if the employee normally works 30 hours per week but reduces their schedule to 20 hours a week for FMLA qualifying reasons, that 10-hour difference for the leave would constitute 1/3 of a week of FMLA leave for each week the employee works the reduced schedule leave. So employers may convert these fractions to their hourly equivalents so long as the conversion equitably reflects the employee's total normally scheduled hour. So where leave must be calculated on an hourly basis, the Department of Labor has clarified that an employee's leave entitlement is not capped based on a traditional 40-hour work week. Instead, the employee's leave entitlement is dependent on the number of hours the employee is regularly scheduled to work. So, for example, an employee, say they normally work a 50-hour work week. The employee's statutory leave entitlement is then 600 hours of FMLA time. So if you've got a 50-hour work week, times the total 12-week leave allotment, that equals 600 hours potentially of FMLA time. If an employee works a variable hour schedule, employers may look to the weekly hourly average that the employee worked during the 12-month period preceding the work week in question. So just keep in mind too that calculations must benefit the employee, not the employer. So in a lot of cases, and you'll hear this more than once today, in a lot of cases, this does come down to basically an individual assessment of the employee, the amount of work they do, how much time they're using for FMLA leave, and how they're using their time. That's something that we can assist you with as our clients when you have questions on specific leave. Today, again, we're just kind of covering the high points, but that's just something to keep in mind that many times it does come down to a case-by-case individual analysis. Let's continue on with an example of counting leave time. Again, FMLA leave is based on weeks. You have to arrive at weeks. Even if you're using an hourly or daily calculation, it ultimately has to go to weeks because you get up to 12 weeks of FMLA leave. So counting leave time, always calculate week by week. So let's take a look at an example here. So you've got a regular work week for an employee, say they typically work 6 days a week. This employee is going to take 2 days a week of FMLA leave. So what fraction of a week has been used? That would be 1/3 of an FMLA week. 2 days out of 6 is 1/3. How long until the leave allotment for FMLA leave runs out for the employee? the employee would exhaust 1 week of leave every 3 weeks. Under this example, an employee would be entitled to continue their schedule for up to 36 weeks. Now, another big question we get, and as we alluded to in the intro, is what about holidays and overtime? Well, the impact of a holiday depends on the situation. Because an employee's FMLA leave entitlement is calculated, again, based on work week increments, how holidays are counted for FMLA purposes varies according to the employee's regular work week schedule. So where a holiday occurs within a work week that an employee has taken off as FMLA leave, the holiday is not going to have an impact. In other words, the employee still counts the full week as FMLA time. Because the holiday in question is simply part of the employee's regularly scheduled work week, it's undeniable that the employee has taken a full week of FMLA leave. Say the holiday falls on a Wednesday, they were taking a full week of FMLA anyway, no question. So where an employee absence or an employee has absences that are measured in daily, hourly, or smaller increments, the holidays do not count against an employee's FMLA leave entitlement unless the employee is regularly scheduled to work on those days. So the presence of a holiday in the work week can impact the percentage of work week calculation where the leave falls on non-holiday days. So the calculation of leave usage must be done on a case-by-case basis in that situation. Again, we're going to emphasize that point today. You're basically going to have to very frequently look at the number of hours the employee works, different factors such as holidays, in order to calculate proper FMLA leave usage. Now let's talk about overtime. It can come into play if an employee is normally required to work overtime, but then suddenly can't because they are using FMLA leave. So in that situation, the overtime hours the employee would have been required to work may be counted against the employee's FMLA entitlement. So for example, if an employee would normally be required to work 48 hours in a particular work week, but due to a serious health condition cannot work more than the 40 hours, the employer may be able to count the 8 hours as FMLA leave because, again, their normal work week's 48 hours. Under that situation, the employee has used 1/6 of a week of protected leave if they are gone for 8 hours out of their normal work week of 48. So in other words, 48 divided by 8 is 6. Another huge topic that comes up is pay and benefits for employees while on leave. So there's many different areas that can come into play regarding substitution of paid leave, short-term disability and work comp, holiday pay, and then how the FMLA relates to the Fair Labor Standards Act for exempt employees. So let's touch on each of these briefly. So as a general rule, as you all know, FMLA leave is unpaid. But under certain circumstances, an employee may elect to, or the employer may require the employee to, in a written policy, substitute accrued paid leave or paid time off, otherwise known as PTO, for FMLA leave. Whether an employee may elect to substitute PTO is determined by the employer's normal leave policy. Again, a shout out to having written policies, especially regarding FMLA. Whether or not use of paid leave is required should be included in your written policy. There's another factor to keep in mind for when an employee chooses to use their paid time off or an employer requires substitution of paid time off during FMLA time. If that's going to happen, the employer must inform the employee that any procedural requirements the employee has to follow for PTO apply only with regard to the PTO payment. So what that means is if you have a policy in place where an employee is required to use PTO while on FMLA, if an employee doesn't comply with the notice period, for example, for using PTO, they might not be entitled to get their PTO pay for that FMLA leave. But the employee, if they're eligible, still has to be awarded the FMLA time off. What that means is that the employee has to follow the written policy regarding PTO to be paid for PTO. But if they don't follow the policy and they're not paid for PTO use, the employer still has to provide the FMLA leave as unpaid leave if the employee is eligible. So what happens if a paid holiday falls in the midst of a leave? Well, we talked about that briefly before, but basically, if it's during a regular work week where FMLA leave is happening anyway, the employee is probably not going to be paid for that holiday. Let's talk about exempt employees. So basically with the Fair Labor Standards Act, exempt employees are those that are exempt from minimum wage and overtime requirements if they meet the qualifications for the exemption. One of the qualifications for the exemption is that the employee be paid on a salary basis. And that salary can't be subject to reduction for quality or quantity of work performed. But with the FLSA, it recognizes that employers should not be required to pay exempt employees for FMLA leave periods, given that that leave is generally unpaid. So because the FLSA recognizes the exemption portion of the FLSA, it does not require an employee to lose their exempt status if the employer makes a deduction from the employee's salary for intermittent or reduced work week leave while on FMLA. So in other words, the FLSA recognizes that an exempt employee may not have to be paid for days that they are gone on FMLA leave. Another big area, as noted in the heading, is benefits. So let's start with healthcare. Basically, an employee on FMLA leave may elect to remain covered under the employer's group health insurance plan. Employees are responsible then for their portion of the premium. What this means is that the employer must maintain the employee's coverage under any group health plan under the same terms that apply to other employees, meaning those that are not on leave. The employee, however, remains obligated to pay their portion of the health insurance premiums. So the employer's obligation is to maintain health insurance coverage for the employee, and the employee has to pay their portion of the premium. Now, if an employee's premium payment is more than 30 days late, the employer doesn't necessarily have to continue that employee's coverage, but the employer does have to give the employee 15 days written notice before dropping coverage. Say the employee's been on FMLA leave, they missed their portion of a premium payment. You can't just simply drop them after 30 days. You have to give them written notice and 15 days to respond. Now, if an employee fails to return to work after the FMLA leave allotment is exhausted, the employer can recover from the employee their share of all health insurance premiums paid during the FMLA leave. So you've got somebody in FMLA leave, they don't come back. As an employer, you can potentially go after them to pay their share of the amounts paid for them and the employer's share to boot. However, you cannot pursue this course of action if they're gone due to a serious health condition that's beyond their control. So under some circumstances, if they don't come back to work, you can recover the full premium from them. From others, if they're still sick, you cannot. Again, you've got to look at this on a case-by-case basis as it comes up. And again, this is something we can assist you with as you go through the process. So other benefits are noted as well on the slide. The employee is generally not entitled to accrue any additional benefits, including seniority, while they are on FMLA leave. It's really, this point, outside of health insurance, is really determined by you as an employer and your established policies and practices for providing benefits to employees who are on all forms of leave, including FMLA. So if an employee is on unpaid FMLA leave and wishes to continue life insurance, disability insurance, or other types of benefits for which they typically pay, the employer has to follow its established policies or practices for continuing such benefits for employees who are on FMLA leave or other types of leave. It has to be consistent, in other words. Now, as an employer, if you have no policy regarding what happens when someone's on leave with their benefits, you then have to look at making an agreement with an employee before they go out on leave. So if you don't have a written policy as to what happens with your benefits before somebody goes out, if somebody's taking FMLA, you should get an agreement from them ahead of time. The other thing to consider if you don't have a policy is to make sure when you're getting agreements on the front side that all similarly situated employees are treated in the same manner. You don't want to randomly treat benefits and employees on leave in a different way. This also ultimately goes back to what we mentioned earlier of the best practice is to have a written policy in place regarding FMLA leave and what benefits apply. Now, looking at managing an employee on FMLA leave, and this is one of the big questions that come up. What can we do with somebody if we've had an issue with them? So let's talk about discipline and termination. Employers don't have to ignore or excuse employees with disciplinary problems, performance issues, just because they are on FMLA leave. But what employers do need to do is proceed with extreme caution when working on a disciplinary issue or a termination issue with an employee who is using or has used recently FMLA leave. You want to make sure that any action that you're taking can be shown through documentation to be based on a legitimate, non-discriminatory or non-retaliatory business reason and not based on the employee's use of FMLA leave. You can also still require employees to follow your call-in policies and talk about their absences, but you have to be careful to not overdo it if you're reaching out as an employer to the employee. It's okay during someone's FMLA leave to check in on them occasionally and say, how are you doing? You know, when are you thinking about coming back? Those sorts of things. But you have to be careful with how much you do that so you don't get into an FMLA interference situation. So if you're going to take a adverse action against an employee who is on FMLA leave or who has recently used it, you want to make sure that you kind of slow down, you know, tap the brakes, take your time, and carefully evaluate each individual situation. We keep coming back to that, but it's such an important point. If you're going to have to lay somebody off, if you're going through a reduction in force, or there's a discipline or termination issue, you've got to be able to show that any adverse action taken is not because of the employee's FMLA leave use. All right, let's take a look at reinstatement. So upon returning from FMLA leave, employees are entitled to be returned either to their same position or to an equivalent position. An equivalent position must also have the same privileges, prerequisites, and status. In other words, it's virtually identical to the former position in terms of pay, benefits, and working conditions. It's got to involve substantially similar duties and responsibilities and has to require basically substantively the same skill, effort, responsibility, and authority. So in other words, if you've got somebody who, say, is a line supervisor and they go off on FMLA leave, best case is they are returned back to their line supervisor position, the same job. If they are not returned to their same job, they have to be returned to an equivalent position, or you're risking an FMLA interference or retaliation claim. So they could not, for example, be returned to a position as a line worker when they had previously been a supervisor. It has to be virtually identical in terms of pay, benefits, working conditions, authority, all those items. Employees are also entitled to equivalent pay. If there's an unconditional pay increase that occurs during the FMLA leave period, like a cost of living increase, an employee who's taking FMLA leave must be given that benefit. Similarly, a pay increase condition on seniority, length of service, work performance must be granted even to an employee that's on FMLA leave. Getting back to what we had talked about before with the same or an equivalent position, when someone's reinstated, they also must have a position where overtime is available at the same level, or the same shift differentials could apply. Basically, too, the bottom line is that pay can include bonuses made to employees, but if a bonus is based on the achievement of a specified goal, such as hours worked, products sold, that sort of thing, and the employee has not met the goal due to FMLA leave, then that particular type of bonus could be denied. The exception to that is if that type of bonus is otherwise paid to an employee who is not on FMLA leave, but on a different type of leave that's not FMLA leave. If they got the bonus too, then the FMLA leave employee must as well. Now, as far as equivalent benefits, those are things like group life insurance, health insurance, disability, sick leave, annual leave, educational benefits, pensions. This again is talking about reinstatement to an equivalent position, same or equivalent position, and then with equivalent benefits. And unless an employee elects otherwise, at the end of their leave, the benefits must be resumed in the same manner and at the same levels as provided when the leave began, subject to any benefit level changes that might have taken place during the FMLA leave, but that affected the entire workforce, not just singled out on the employee that took FMLA leave. Additionally, an employee can't be required to meet any qualification requirements to get their reinstatement of benefits. So if somebody is on FMLA leave, it's job protected, it's also benefit protected, and they basically must be reinstated on the benefits after FMLA leave. People often ask questions about retirement plans or pension plans. It's similar to what we were just discussing. An employee on FMLA leave is entitled to be treated as if they remained continuously employed throughout the period during which the employee was on FMLA leave. So if you've got an employee that's taking FMLA leave, it's not to be treated as a break in service that affects vesting or eligibility to participate in pension or retirement plans. And employees, again, can't be required to re-qualify for those benefit plans. They just have to be continued in those plans. Another big part of reinstatement with equivalent terms and conditions of employment is somebody's work site and their shift or schedule. Basically, the employee has to be reinstated to the same or a geographically proximate work site. They're also entitled to return to the same shift or same equivalent work schedule. So you've got to be careful if someone's been out on FMLA leave to make sure that they're back at their same facility or one that's pretty close and that they're on the same shift. Not doing so could be viewed as an FMLA retaliation issue. There are some listed requirements and situations where reinstatement might not have to happen. Some of these we've touched on, but we'll just kind of go through this list briefly again. A layoff situation, a shift change, the end of employment in terms of a set length of an employment term under a contract, or the end of a project. Key employees. Now let's talk about those folks for a minute. So a key employee are those employees that are among the highest paid 10% of all employees in the employer's workforce within 75 miles of the employee's work site. So key employees may be denied job restoration when it's necessary to prevent a substantial and grievous economic injury to the employer's operations. That's right out of the statute. So what that basically means is that an employee who is a key employee may not have to be reinstated if it hurts the bottom line of the company, but that's on the back side. But on the front side, the employee still has to be offered the FMLA leave. You know, they must be offered the time to take the leave if they're eligible and if they qualify. The difference is that at the end of that leave that they have qualified for, they may not have to be reinstated. Other instances where reinstatement is not required, teachers returning from leave, pending a fitness for duty examination, which we'll touch on in a little bit. If the employee is unable to return to work for different reasons. If during FMLA leave, an employee has violated your fraud or moonlighting policy. If the employee has lost a certification or licensure that's required to do their job, and if there's a physical impossibility for an employee to return. Let's look again at the fitness for duty certification. So an employer can have a policy that's uniformly applied, requiring that prior to an employee being reinstated following FMLA leave, they must provide a certification of their ability to resume work. Now, there are some prerequisites that are involved if an employer wants a fitness for duty certification for a returning employee who's used FMLA leave. So only employees who are on leave due to their own serious health condition may be required to provide a fitness for duty certification as a condition of returning to work. So if somebody's out for, say, baby bonding leave on FMLA, you can't do a fitness for duty certification. It's only for their own serious health condition. Regarding the fitness for duty certification requirement, an employer can't impose this requirement unless it has a uniformly applied policy or practice that applies to all similarly situated employees. So if you've got maybe some type of active work and you've got a department that performs that type of work, you can require fitness for duty certification for that department, but it has to be across the board for everyone. It has to be the entire work unit. There also has to be pre-leave notification by the employer. So if an employer requires an employee to provide fitness for duty certification as a condition of returning to work, you have to give the notice of the fitness for duty certification requirement to the employee at the time the employer provides the FMLA designation notice to the employee. So you have to give them notice of the fitness for duty certification requirement in writing, unless it's already in your employee handbook that the employee has acknowledged. As far as the fitness for duty certification itself, an employer can choose to accept a very simple statement saying, Joe Smith is ready to come back to work, or it could require the employee to provide a certification of the employee's ability to perform each of the essential functions of the job. Just keep in mind, again, you want to have a uniformly applied policy for similarly situated employees. In other words, don't treat people differently. Fitness for duty certification, it should be noted, is not applicable for people that are taking intermittent FMLA leave or reduced schedule FMLA leave. Another huge area that we run into in terms of questions from our clients is, how does the FMLA work with our company policies, and how does it work with other federal, state, and even local laws? So as noted here on the slide, as if the FMLA wasn't complicated enough, it's required to quote unquote play nice with your company policies and a myriad of other state and federal rules and local rules in some cases. So let's start off with the company policies and their effect as related to the FMLA. Say, for example, you're an employer and you've got a no-fault attendance policy, meaning employees are allotted a certain number of absences after which they will be disciplined for additional absences. 3 absences in a month, you're disciplined. This is very problematic with FMLA. They could penalize an employee who takes FMLA qualifying leave, which is not permitted under the statute. You can't penalize an employee under a no-fault attendance policy for using FMLA leave. That's prohibited by law. Call-in procedures. So you've got an internal procedure. There could be discipline for no call, no show, excessive tardiness, things along those lines. So absent an emergency situation, if an employee is aware of a need for FMLA leave less than 30 days in advance, the employee is basically required to provide notice of the need for leave either the same day or the next business day as soon as they know. As an employer, you can enforce a non-discriminatory call-in procedure unless your call-in procedure is more rigid than what's allowed for under the FMLA law. Again, same day or next business day. If there are unusual circumstances that prevent an employee from seeking FMLA protected leave that would prevent them from complying with your procedures, the employee will be entitled to FMLA leave as long as the employee follows the employer's call-in policies as soon as they practicably can do so. So let's say, for example, an employee's in a car accident and they're not able to contact the employer for several days. Once they are able to contact the employer, they should not be penalized if they qualify for FMLA leave for violating the call-in policy. FMLA also allows employees to elect, or as an employer, you can require an employee, as we touched on earlier, to substitute paid leave or use paid leave during FMLA leave. And the paid leave can be under a PTO policy, vacation policy, sick leave. In other words, the employer can require that the employee's paid leave time, let's say PTO, for example, can run concurrently with their unpaid FMLA leave. So what that means is you've got an employee, they qualify for FMLA leave, that's unpaid, they're taking it. You can have a policy in place as an employer saying, hey, if you've got unpaid PTO, you are required to use it during your period of unpaid FMLA leave, and that PTO leave use will run concurrently. Let's talk about another big area of overlay between a couple different federal laws. And that would be the Americans with Disabilities Act, ADA, and the FMLA. They're entirely separate federal statutes with different purposes and different protections, but as we will discuss, sometimes they can meet for certain employees. So ADA, the purpose of the ADA is to give qualified disabled individuals access to a job. For someone to be covered under the ADA, there's no length of service requirement, and an ADA accommodation does not necessarily have a stated length of time. Now let's look at the FMLA. The FMLA is about giving employees who are eligible a protected right to take off work, meaning they get job protected leave under the FMLA if they meet the eligibility requirements. However, different from the ADA, the FMLA does have a length of service requirement. You have to have worked a certain number of months and hours, and it has a 12-week duration. FMLA leave does not extend beyond 12 weeks, except in the case of a covered service member related FMLA leave, as we discussed earlier. So what is a common scenario that comes up with FMLA and ADA? The ADA could require that an employer provide additional unpaid leave after FMLA leave runs out. So you've got an employee, they've got a serious health condition, let's say. They use their 12 weeks of FMLA leave, and as they're getting ready to come back, you follow up with them and they say, hey, I'm looking forward to coming back, but my doctor says I need 2 more weeks of leave. So the FMLA leave is going to run out, but if providing the 2 additional weeks of unpaid leave under the ADA would be a reasonable accommodation that wouldn't cause an undue hardship to you as an employer, the employee likely will have to be given that extra 2 weeks of leave under the ADA. Again, absent undue hardship. The other point to consider with the ADA is that it applies to much smaller companies than FMLA. FMLA applies to companies of 50 or more employees. ADA is 15 or more. Here's another example. Say an employee has suffered a stroke. They've used their FMLA leave. They go to the employer and say, I need some additional time, as we just mentioned, with getting back to work. So under the ADA rules, if it's not an undue hardship, the additional leave may be a reasonable accommodation that the employer would have to give, as we discussed. Also under the ADA, there could be other factors that could come into play in terms of workstation, things along those lines. Those are a little more in depth and probably a topic for another webinar, but you can see how these two rules can dovetail together, even in the area of leave. If someone's used their 12 weeks of FMLA, they need a little bit more time, an employer could very likely be required to grant that as a reasonable accommodation under the ADA. Another huge area of development that we've all seen in the last few years are state-specific leave laws. So many states, as you've heard, are coming up with paid sick leave, paid family leave, things along those lines, which could also apply to and overlap with FMLA leave. So again, you want to look at everything on a case-by-case analysis. If you're looking at an employee's qualifications for FMLA leave, you also want to consider if they would also be eligible for a state, and in some cases even a county or city leave law as well. All those laws don't cancel each other out. Instead, they have to be read as working together where it's applicable. So you could potentially have a person that's eligible for FMLA leave, and they could also be, as shown on the slide, eligible if they work in the state of Minnesota, for example, for parental leave under the Minnesota Parental Leave Act. The requirements of employer size and type of leave are slightly different, but there is an overlap in other areas as well with 12 weeks and what situations under which an employee can take a state leave. So they could have, in some cases, employees that are subject to, again, the federal as well as state and maybe even a local county or city paid leave. You do want to work on those on a case-by-case basis, analyzing the laws. And again, that's something that we can assist you with if you have a specific employee when a leave question comes up with FMLA. Another area that frequently comes into play is state workers' compensation law. There are many states out there, and again, it can be very state specific, who allow leave for work-related injury under their own work comp act of that particular state. So if an employee is injured at work, the work comp statute might state, well, they can take time off. Generally, these laws are written so that they run concurrently with FMLA leave. Meaning you can, as we discussed earlier, have the employee who is eligible for FMLA take FMLA leave, but also designate the leave as covering work comp leave and potentially other types of leaves as well at the same time. They can all run concurrently. Different, however, under work comp laws than FMLA is that FMLA leave is unpaid. But an employee who misses work due to a work-related injury and is eligible for FMLA coverage might be able to receive work comp benefits, usually up to 2/3 of their regular pay during their leave. So this works into when you have an employee, they're going out on FMLA leave, you want to make sure that you're looking at all of the possible avenues of leave that they could be eligible for. So FMLA, the federal law, then look at the state and even the local laws, and that could include a work comp law. Work comp leave, when running concurrently with unpaid FMLA leave, may have some compensation mechanism. Similarly, as we discussed on the last slide, some states have paid leave that a person who is on an FMLA qualifying medical leave may also be eligible for state paid leave for a medical reason, and they may receive some payment during that leave. It just would not be for the FMLA portion or under the FMLA. It would be under the concurrent running law with the state local jurisdiction. With this type of stuff, remember, compliance is not optional. It's required. One of the good things about the service we offer is that we're here to help you. We're here to answer these questions, the federal laws that stand alone, and also the additional overlay of state and local laws, and as those questions apply to any individual situation. Again, apologies for the audio issue yesterday. You can still submit questions to us that we can answer. And if you're a current client, you know that process. If you're not a current client and you're interested in learning more about our services, you can contact us as shown here on the screen. Thank you all for attending, and we look forward to your attendance at future Third Tuesday webinars.